We are here on cause number 21. If the parties could make their appearances for the record, beginning with the Assistant Attorney General.
Yes, good afternoon. David LaRosse, Assistant Attorney General representing DCYF.
Good afternoon.
Good afternoon, Your Honor. This is Brittany Ramos. I am the assigned DCYF social worker for this matter.
Good afternoon, Ms. Ramos.
Jenny Cowan. I represent the CASA, Brianna Johnston-Hanks.
Good afternoon, Ms. Cowan, and good afternoon, is it Bronston-Hanks?
Thank you, Your Honor. It's Johnston-Hanks.
Johnston-Hanks. Thank you.
Yeah.
And then Ms. Zayas, good afternoon.
I'm mother, and there's going to be loud lawnmowers.
Okay. So we are here to begin trial this afternoon. I want to let the parties know what I received and reviewed, and then we can talk about whether this will be an entirely remote trial or if anyone wishes to appear in person, and then we'll talk about scheduling. So I did review a brief from Ms. Cowan, a brief from Mr. LaRosse, and 2 emails and an attachment pleading from Ms. Zayas. Am I missing anything? I also have the exhibit list and the witness time estimate. Am I missing anything from any party beginning with Mr. LaRosse?
I don't believe so, but in regards to the emails from Ms. Zayas, I'm sorry, I didn't have a chance to check if these were filed, but one was entitled Exhibit List, 23 pages, although it's not really an exhibit list, it's more of a trial brief, and the other was the reply to AAG's trial report, which is 3 pages. Is that what the court was referring to?
Yes.
Okay, thank you. I think that's it then.
All right. And there was some content in the email, so we have filed all of the emails that we received, so they should be in script if you want to make sure that you received them and have been able to review them. So anything else from DCYF or from the CASA?
In regards to filings?
Yes.
No, not from the department. Thank you.
And Your Honor, Ms. Johnston-Hanks did file a report to court, but I have not submitted that as an exhibit. At this time, I may upload it into ShareFile, and I will make sure that Ms. Zayas and Mr. LaRosse get a copy of it if I intend to introduce it as an exhibit. Thank you.
Thank you. And Ms. Zayas?
It just occurred to me that I did send the court and the parties a form FFCL for termination trials. It had nothing specific to this trial.
Yes, I did see that.
Okay.
Yes, thank you. Ms. Zayas, I did review, let me tell you the documents that I reviewed that we received from you, just to make sure I've got everything. So I did receive an email dated Friday, 7/15, 9:38 p.m. I reviewed that. I received an email indicating that your only witness would be your son. So I received that. That was July 15th at 4:30 p.m. I received your exhibit list, your trial report. So did I list everything that you've submitted to the court, Ms. Zayas?
Yes.
Thank you. All right. The next issue I'd like to take up is the nature of the proceedings. So everyone has appeared by Zoom today, and the court is happy to conduct this trial by Zoom if that is the wish of all of the participants. The court is also happy to have any of the participants in person in my courtroom at any time. So everyone is welcome to come. If you were to be here in person, the only requirement is that everyone in the courtroom has to wear masks. And so other than that, we are pretty much open and operating normally pre-pandemic. So let me just ask first, Mr. LaRosse, does the state wish for the trial to proceed by Zoom?
I am perfectly comfortable and in fact in favor of that, Your Honor. However, I do want to state that I think that even if all the parties are in agreement, it's still necessary for the court to conduct a Matthews v. Eldridge balancing test, which I would like to address after the court checks with everybody.
Ms. Cowan, what is your preference?
Yes, Your Honor. Ms. Johnston-Hanks and I would prefer to appear by Zoom if the court allows us to. And I agree with Mr. LaRosse to address the Matthews factors as he is briefed in his trial brief before the court makes a decision. Thank you.
And Ms. Zayas, what is your preference? To have the trial by Zoom or to come in person?
It's fine by Zoom.
Okay. And let me ask you this, Ms. Zayas, can you tell me whether or not appearing by Zoom is better for you than coming in person every day? What's the best way for you to have access to this proceeding?
Well, if my rights get terminated by Zoom, I'll be mad at Zoom.
Are you able to come in person every day?
I can if you want me to. It doesn't. I don't know. It doesn't matter. But I guess Zoom is fine for now.
Okay. Is Zoom more convenient for you?
Yeah.
Okay. And I see that you have your child with you. If we had these proceedings in person, would you be able to find care for your child?
No, I'd have to bring her with me. She's not in daycare yet. Okay. Or actually, I could son watch her, but I don't know. I have to ask him.
Okay. So you don't have childcare lined up if we were to conduct these proceedings in person?
No, I've been to all the child cares around here, so they don't tell me they have an opening.
And I don't need to know your precise location, but how far away from the King County Courthouse in downtown Seattle are you?
Oh, downtown Seattle? Probably like 45 minutes.
Okay. And do you have reliable transportation to the downtown courthouse?
Yeah.
All right. Is there anything else that makes appearing by Zoom more convenient for you that I've missed?
No, that's it.
Okay. Thank you very much. All right. Mr. LaRosse, go ahead.
Yes, thank you, Your Honor. So I provided some briefing in the trial memorandum regarding the requirements on an individualized basis for the court to determine whether in a specific case, a hybrid trial or a full Zoom trial comports with due process. And the test to be employed is the Matthews v. Eldridge test, which requires the court to balance three different factors. One is the private interests at stake, one is the state interests at stake, and one is the risk of erroneous deprivation if the procedure that is being contemplated is used in lieu of having everyone else appear, having all of the parties and witnesses appear in person in the court. And in terms of the private interests, we have the interest of the mother, which is her fundamental right to parent the child. We have the interest of the child, which is a right to a rapid establishment of permanency in a safe, stable, and appropriate home. And then in regards to the state's interest, the state shares the same interest as the child, which is that right to establishment of permanency for a child who's been in out-of-home care for some 2+ years. All of the parties also share an interest, however, in not getting COVID. And given the prevalence of the new BA.5 variant, Ms. Zayas can speak to her susceptibility given her particular medical issues. I am someone who is particularly susceptible or at a higher risk of problem given my own medical circumstances if I were to be exposed to COVID. And so I definitely have a strong interest in not putting myself at risk to that. I believe Ms. Zayas has the same. I don't know about the other parties. And then the next, so I guess I would summarize by saying that the various private and state interests are all of comparable weight and not necessarily determinative of the question, which really rests then on the question of a risk of erroneous deprivation. And the primary considerations in terms of risk of erroneous deprivation by use of Zoom at trial are essentially the ability of the parent to fully participate and the impact on the use of Zoom on the parent's ability to effectively work with their counsel. The second of those is moot because Ms. Zayas is representing herself. Whether we proceed by Zoom or in court, the question of adequate ability to work with counsel is not at issue here. Ms. Zayas has indicated that she would prefer to appear by Zoom. The court has obviously been using Zoom for the past 2.5 years to conduct its trials. I will note that in many of those trials, judges have observed that Zoom is actually, in some sense, preferable due to the fact that they are able to have a full face-on view of the witnesses without masks. And were there to be a trial in person in the courtroom, the court would be having a side view of witnesses wearing masks. And so that's actually a detriment compared to the ability to observe the witnesses via Zoom and also potentially to understand them because of the lack of obstructing masks. There is not a risk of erroneous deprivation that is presented by conducting these proceedings via Zoom, and therefore the department is requesting a finding from the court that proceeding in this manner does comport with due process. Thank you.
Ms. Zayas, Mr. LaRosse suggested that you might have some health concerns that would be relevant to whether it would be safe for you to come to court. Would you like to generally tell the court whether that's correct or not?
I'm not taking any medication right now, but sometimes I get high blood pressure, but I haven't had it in a while since about 6 months after having the baby. So no, I don't. Not right now.
Okay. So you don't have any issues that make you particularly susceptible to complications if you were to contract COVID?
I've had COVID already. Being old, I guess, but I've already had it. I had it a year ago.
Okay.
Me and the baby both had it.
All right. So the court will observe that having done numerous Zoom trials, the representations that Mr. LaRosse makes about the court's ability to perceive witnesses and make credibility determinations and the effectiveness of the Zoom platform for trial for counsel and parties to be able to do the same is correct. If we were all in person, we'd all be wearing masks, and not only would the witnesses be wearing an awkward, clear face mask that's transparent, but it does obstruct some facial expressions. But the parties and the lawyers wouldn't be able to view each other in a way that might be important. For example, Ms. Zayas wouldn't be able to view Mr. LaRosse's face at all times, and that might be detrimental to her presentation of her case. So as far as the right of confronting witnesses and the ability to confront witnesses and gauge credibility, that is in some ways enhanced by the Zoom platform as opposed to being in person. Mr. LaRosse does have health concerns that require this court to balance protecting his health risks with an in-person trial. And frankly, given Ms. Zayas's preference for a remote trial in having to find childcare for her small child and traveling 45 minutes each way to the courthouse every day, the court finds that balancing those, her interests with the interest of Mr. LaRosse's health, that the Zoom platform wins out in that balance as well. Ms. LaRosse doesn't have counsel, so although we can accommodate, and we have accommodated the ability for counsel and parties to confer, that's not an issue, and the court will accommodate the state and the CASA conferring with their clients during the trial in a way that satisfies. And given this court's experience with Zoom trials and the representations of everyone participating in this case, the court finds that Ms. Zayas's due process is not only satisfied by a Zoom trial, but in some ways enhanced because she has a better access to the court this way than she would if she were to come in person. I am looking at Ms. Zayas's internet connection. It appears to be stable, and in other people's, the CASA and the state's internet connections seem to be stable, so I don't have any concern about access to efficient technology to participate. That also weighs in favor of a Zoom trial. This case has been on the calendar for quite some time, and if this court were to wait to try this case until health situation, I don't really know when that would be because it seems to be a moving goalpost, and so there really is no reason to consider moving this trial in order for all of us to be able to appear in person without the state's counsel's health concern rising to a level of creating an interest that outweighs getting together in person and doing this trial. So for all of those reasons, and the child in this case has an interest definitely to resolving this issue as soon as possible, as does Ms. Zayas and as does the state. So I'll just ask Mr. LaRosse, are those findings, in your view, sufficient to proceed by way of Zoom?
Yes, thank you, Your Honor.
Okay, let's talk about scheduling then. I understand that we may have some scheduling issues coming up this week. So the courts would intend to begin this afternoon. I don't know if there's any motions, but begin this afternoon with the trial and be in session all day Tuesday, all day Wednesday, all day Thursday, and then again next week. The only time the court in need of being in recess is next Monday morning, and so we would begin at 1:30 on Monday the 25th, and then be in session all day next Tuesday, Wednesday, and Thursday, the 26th, 27th, 28th. Hopefully completing the trial by the 20th. So, Mr. LaRosse, if you would please begin with letting the court know any scheduling issues that it should be aware of as we proceed.
I will have to defer to Ms. Ramos for her scheduling. I'm not aware of any issues that she has. The only issues that I have is that myself and Ms. Johnston-Hanks have a hearing before Judge Ferguson at 8:30 tomorrow morning, and we have informed the court that we're going to need to commence trial in front of Your Honor at 9 o'clock. So we've asked them to proceed expeditiously with that matter. It's not the sort of thing that I can really get coverage for. It's a pretty complicated motion. So my hope is that we don't run slightly over and that we're able to conclude that hearing with Judge Ferguson by 9 o'clock. But of course, I'm not 100% in control of that.
Should we begin at 9:15 tomorrow then? Would that give a cushion, or is 9:30 a better cushion?
Could we set it for 9:15, and then if there are problems, I can email the court? I think that Judge Ferguson has another matter at 9. I'm not 100% sure, but my guess is that because he set it at 8:30, it's because he has other things to do. So it's my hope that we will be able to get that done expeditiously.
Okay. Well, we'll set tomorrow, the 19th. We'll begin at 9:15. And of course, if things go awry, just let us know.
Okay, thank you. I do want to note I have a somewhat complicated matter at 8:30 on the dependency calendar on Thursday, and I'm going to do my very best to get coverage for that. If that becomes a problem, I may raise it with the court tomorrow. Well, one of the complicating factors is that Ms. Zayas informed the parties in the court today. She has a 10:30 appointment tomorrow morning, and I have 2 separate witnesses scheduled, professional witnesses.
It's Wednesday morning. Oh, wait, is that Wednesday morning?
My mistake, Wednesday morning.
Yeah.
So depending on what the court determines to do with that situation, I may have to reschedule those witnesses, although I would prefer not to. I anticipate that I am hoping to conclude the state's case by next Monday, if not before, but that in part depends with what we do about this coming Wednesday morning.
Okay. All right. Anything else from...
I don't have any, but I'll just ask Ms. Ramos to confirm whether she has any issues.
No, Your Honor, I do not have any other issues. I did find out recently that child in this matter has an appointment on Thursday at 12:30. And I know that the plan was to have myself involved in that appointment, as well as Ms. Zayas if she is available. I understand the court is on recess at that time, and I don't know how long the appointment will go to. So that is the only conflict, if any.
So,
yes.
And what would the travel time be for you to attend that appointment and then get back? Because the court would intend to accommodate that.
At most 10 minutes each way.
Okay. Perhaps we start at 2 on Thursday afternoon. Let me inquire of Ms. Zayas what her travel time would be, and then we'll make a decision about what to do on Thursday. Okay. Before I get to Ms. Zayas, Ms. Cowan, any scheduling issues?
No, Your Honor. Thank you.
Okay. All right, Ms. Zayas. First of all, let's talk about this Thursday appointment. That seems to be one we should resolve first. What is your travel time to get to the 12:30 appointment on Thursday?
I didn't know anything about it until she just said that.
Okay.
Yeah, I don't know. I've never been there before. I don't know where I'm going or what.
Ms. Ramos, do you mind telling Ms. Zayas where she would be going?
I have to get approval for her to be able to attend because this appointment is being facilitated by the foster parent who is the caregiver. There are concerns of safety with Ms. Zayas attending that appointment, so I may only be able to have her attend by phone.
I have to go up there anyway to get her records, so I might as well go up there.
The appointment is in Seattle, so if she attends in person, it sounds like it's a 45-minute drive for her each way.
Okay. So perhaps this is premature. Ms. Ramos, I understood when you first mentioned it, you said she might attend. So now it's premature that she might attend. Is that correct?
Correct.
All right. Then let's not get into it until you know for sure whether she's going to.
Yes, I can.
All right. Very good. So figure that out, and then we'll discuss the Thursday schedule then. So Ms. Zayas, I understand you may have something Wednesday morning. Please tell me about that.
Yeah, I have an appointment at 9:30 at the airport. Sorry.
That's okay. And what kind of appointment is it?
I have to go take a drug test. It's just a mouth swab, so it takes like 5 minutes. But I don't know if they have me do it right when I get there. They might have me wait because they usually do just in case people chew gum or something before they come.
Okay.
So they might have me wait like 10 or 15 minutes when I get there and then take it, and then I can just go.
Okay. And what's
Where I start work on August 22nd for Alaska Airlines.
do you have an email or some other confirmation of that appointment time?
Yeah, I can get that.
Yeah, would you forward that to Ms. Stronsky, the Court McCoy?
Okay.
And then we will determine if you can forward that. Do you have the ability to do that this afternoon?
Yes.
Okay, let's do that this afternoon, and then upon confirmation of that, and the reason I'm asking is just because if you do have confirmation of that, then I'm going to ask Mr. LaRosse to reschedule his witnesses, and so I want to make sure that we are certain of the time and the place and the date before I ask him to.
Yep, I'll do that.
All right, thank you very much.
I'm sorry, Your Honor, could I ask, just to avoid ex parte communications, that all parties be CC'd on that email?
Yeah, Ms. Zayas, could you include Mr. LaRosse on that email as well as Ms. Cowan?
Yeah.
Yeah, you've probably been doing that for a while, including everybody on the emails.
Yeah, sometimes, yeah.
Okay, so going forward in this trial, if there are things that I ask for you to send to my bailiff or to the court, if you would always include everyone on the email. If you don't, Ms. Stronsky's going to forward it to them anyway, so it's expeditious to go ahead and include everybody on the correspondence.
Okay.
Thank you very much. Okay, and other than your Wednesday appointment, Ms. Zayas, do you have any other scheduling issues this week or next?
No.
Very good. All right. So during the afternoon break, which will take about 2:45, I would imagine, I'm going to ask Ms. Zayas to forward counsel and the court a copy of that email. And then when we come back from break, we'll discuss the scheduling issue on Wednesday. And then Ms. Ramos will give us an update on the Thursday issue tomorrow, and we'll discuss that then tomorrow when we have all that information. Okay, so now I'm just going to go round robin again. Mr. LaRosse, are there any other pretrial issues that we need to discuss before we begin? Are there any motions or any other pretrial matters?
There are not any other motions, Your Honor. I do have a handful of issues that I think are best resolved prior to commencing opening arguments, if I can sort of run down the list of those. They are not motions. They are issues, for instance, addressing the fact that this is an open courtroom, addressing the application of ICWA and the Service Members Civil Protection Act. Okay, so thank you. I said there's a couple different ones, but the first is addressing the matter or the fact that this proceeding is being held in an open courtroom for the court to address that on the record.
All right. So I am sitting in courtroom West 817 in the King County Courthouse. Currently in the courtroom, as you can see on the screen, there are no observers. It is simply me and the court clerk, Mr. Mason. He's right below me and he's not visible on this camera. So we are the only two in this courtroom. The courtroom is unlocked. If anyone were to open the door and walk in and sit, they would be welcome to stay. The courtroom will remain unlocked during these proceedings, and is for that reason, and that is all that the law requires to make this an open courtroom. We have a Zoom link that my bailiff will only give out to identified people. So if, for example, another person from the Attorney General's office, like another lawyer or an investigator, wish to watch the proceedings, they would be welcome to watch them by Zoom, but that person should identify themselves when they request an email link. I'm going to ask that if any of the parties share the Zoom link with anyone, that you make sure that that person knows they need to identify themselves when they join the Zoom. And Ms. Stronsky won't let anyone into the Zoom link who is unidentified. The reason that we do that is we can't risk having witnesses watching proceedings and then us not knowing that they're witnesses and then having watched, then testifying. So that's the reason for that. Any other record that you'd like the court to make, Mr. LaRosse?
Not on that issue. Thank you, Your Honor.
Yes.
The next issue to address would be the application of the Service Member Civil Relief Act. The mother is not a member on active duty with a member of the armed forces or on active duty with such, so that act does not apply. If anybody has any contrary information, I would ask that they provide that to the court. The application of the Indian Child Welfare Act, it's required for the court to inquire of the participants whether any participant knows or has reason to know the child has Native American ancestry. The mother has specified that she does not have Native American ancestry, therefore there is no reason to know the child is a member or eligible for membership in a federally recognized tribe, and ICWA does not apply. If anyone has any contrary information, I would ask that they provide it to the court. Thank you.
Ms. Cowan, first do you have any contrary information?
No, Your Honor.
Thank you, Ms. Cowan. Ms. Zayas, do you have any contrary information?
I do want to touch on a couple of matters quickly, just because they have been issues within the prior dependency and these termination proceedings. First, in regards to the need for a litigation GAL, that has been previously addressed on the department's motion, and I wanted to clarify for the record that litigation GAL has not been ordered, and the department is not aware of any change in circumstances indicating that the mother has a lack of ability to understand the nature of the proceedings or the impact on her best interests. And I think it's demonstrated by the filings that she has made and submitted to the court yesterday that she's an intelligent person with a full grasp of the nature of the proceedings and the impact on her interests. But I just wanted to put that on the record. If anybody has any contrary information, I would ask that they provide that to the court.
Ms. Cowan, any contrary information?
No, Your Honor.
Ms. Zayas, any contrary information?
This court doesn't have jurisdiction of me unless I abuse my child or neglect my child. So there's no jurisdiction. So everything that he says is like Charlie Brown's teacher. Want nothing. That's all.
Thank you. The next issue is similar in regards to the mother's decision to proceed pro se in this matter. That motion was previously granted within the termination and the dependency proceedings. The department is not aware of any change in circumstances that would indicate that her decision to proceed by representing herself rather than via representation through an attorney is anything other than knowing, intelligent, and voluntary. If anyone else has contrary information, I would ask they present that to the court.
No new information that changes the circumstances from the last time the court considered this issue. Thank you.
Attorneys work for CPS.
The next question is simply one of efficiency. Because this is a bench trial and because it's assigned on rather short notice, there may be times in which the department or other parties may request to take witnesses out to fill in gaps, especially if there's a situation where the witnesses, for instance, who are scheduled for Wednesday morning are not able to proceed because the court allows the mother to attend her UA, I will need to reschedule them, and as a result may have some gaps in the way the witnesses are scheduled. And so, for instance, there might be a request to call Ms. Ramos out of order to present factual testimony rather than presenting her as the department's final witness to present factual and opinion testimony, or potentially asking for the CASA to be called out of order, or if the mother comes up with a witness she wants to be called, maybe having that person called out of order. And I just wanted to alert the court to that potential issue before we begin.
And this court is extremely flexible with witnesses generally in all cases. Understand people have schedules and that this case was assigned out at the last minute. So I just ask that you help me know where we are when we left off. For example, if you were to call Ms. Ramos and present an hour of Ms. Ramos's testimony and then she is interrupted by another witness, that's perfectly fine. When we resume, Ms. Ramos, if you could just assist the court in picking up where we left off. The only reason I say that is you all know this case way better than I do, and so to the extent you can keep us organized, even though we're being flexible with calling witnesses, the court would appreciate it.
Okay, absolutely. Thank you. One more question that I have, and procedurally, is that the department would like to request entry of certain exhibits consisting of court orders, filings of the mother, etc., prior to taking of testimony. And I don't know whether the court wants to address that or after opening statements.
I'm content to do it now if that would expedite things. And if there's an agreement by Ms. Zayas, and in the absence of an agreement, then the court is happy to rule, if the court can rule. You're listing exhibits that seem to be self-authenticating. Is that correct?
Yes, and also admissions of a party opponent in the sense that there are filings by Ms. Zayas.
All right. I'm happy to do that. Would you like to do that now or after we?
That's actually the end of my list, unless anybody else has any other pretrial issues.
All right. Let me ask if there's other pretrial issues, and then we'll come back to this, and I'm happy to accomplish it before opening statement. Ms. Cowan, do you have any matters you'd like the court to address before we begin trial?
No, Your Honor. Thank you.
Ms. Zayas, do you have any pretrial motions?
They told me this last week, so I have no exhibits. I have no witnesses because they told me this last week. Mm-hmm. I never thought I would have a trial. So what I don't have is because of they told me this last week. And yes, I want it now. I don't care if I don't have anything, but that's the reason that nothing's here. Last year, when they were supposed to have this trial, I had everything ready and they didn't have it. So, and I actually sent it in too. So basically they already have everything, but probably threw it in the garbage. Ouch.
So, Ms. Zayas, I will just let you know if there's anything that you do want to submit. Excuse me, you won't begin your presentation until Monday of next week. So, if you'd like to upload documents to the share file or submit exhibits to the court, you have time to do that. Okay. Thank you. All right. So then we will turn to exhibits that the state is offering. And let me get into the share file so I can look at them if necessary. All right. And I am ready when you are, Mr. LaRosse. Go ahead.
Thank you. And I'll just warn everybody that this is going to be an extensive list. The first group of exhibits the department is asking to enter consist of exhibits 1 through 4. And Exhibit 1 is the prior agreed order of dependency entered by the mother in 2014.
Am I allowed to say I object to these? When do I say it?
Okay. That's a good question, Ms. Zayas. Let me talk through the procedure. So we'll go exhibit by exhibit. Mr. LaRosse will offer it, and I'm going to have a look at it, and then I will ask you whether you agree or object and the basis for your objection if you have one. And then I'll let Mr. LaRosse respond, and then I will rule.
Okay.
Okay? All right. Okay. So let's take Exhibit 1. So you're offering Exhibit 1, Mr. LaRosse?
That is correct. And Your Honor, in offering that, I would like to notify the court that the pretrial conference order that was entered on March 25th indicated that electronic copies of the orders entered into dependency, termination, and parenting actions involving the parents or alleged parents are deemed admissible, authenticated for purposes of admissibility. Certified copies of all criminal and civil court records regarding the parents are deemed authenticated. So I just wanted the court to be aware of those prior.
Addressing authenticity.
Yes.
Okay. All right. So as to Exhibit 1, Ms. Ice, do you have an objection?
Is option C marked on the statute of authority?
I'm sorry, say that again?
Is option C marked under 1334-0306 is C marked?
Are you asking me a question about what's on the exhibit? Are you able to see the exhibit?
No, I can't see it.
Do you have your share file?
No, I never was sent a link. They said they would send me a link in a different email. I never got a link in a different.
All right, let me make sure that you have to be able to see these in order for us to carry on. So when you say they said they would send you a link, who said they would send you a link?
Somebody at dependencycourt.gov or something like that.
All right.
People in charge of the documents, I guess.
Okay. All right. Let me figure that out. So, Joe, how do we get? All right, Ms. Ice, give us just a moment. We're going to try and send you a link.
Your Honor, while everyone's working on that, can I take 2 minutes to step away?
Yes.
Okay, thank you. I'll be right back.
Mm-hmm. All right, Ms. Ice, what email would you like this sent to?
The Hotmail.
The Hotmail?
Be quiet, Mark. I'm on the phone, okay? You got to be quiet. Yeah, okay, I'm on the phone. The Hotmail one.
All right, let me get that up here for our clerk. All right, Ms. Ice, our clerk just sent you the link, and it said it sent successfully, so let us know.
What number file is it? Oh, just one. So how many years are we allowed to go back as far as evidence goes? So we can go like 20 years ago? Is that how it works? I don't know.
So right now we're just talking about Exhibit 1, so I just want to make sure you can see it.
Yeah, from like how many years ago? From like 8 years ago, I think it was. Was that 8 years ago? Yeah, it was when she was born, so it's from 8 years ago.
Okay. Well, do you have an objection to Exhibit 1?
Yes, I do.
All right. And what is the basis for your objection?
I was forced under arrest to sign this from crooked CPS officials who I never even read this thing. When I first started getting my kids took away, I never read any court documents. I couldn't because mentally I would just go nuts. So yeah, no, I didn't read this crap.
Mr. LaRosse, and you're offering this as it's self-authenticated. It's a certified court document and per the pretrial order and the factual statements in it. I'm assuming you're offering as adoptive admissions of Ms. Zayas. Is that correct?
I am, and I would like to note that if there was some objection to the order, that the appropriate remedy would have been to have challenged the order, sought to have vacate the order. There's no motion to vacate or order to vacate that order, and I would object to the mother's statements about what everybody else told her as hearsay. So I would ask that the exhibit be admitted. Okay. Thank you.
So the court will find that this exhibit is admissible and will admit it into evidence. The statements within it attributed the factual statements.
I never seen that, and I never signed it. So you're admitting something that I never signed.
Thank you, Ms. Ives. They are adoptive. Not for you. They are adoptive admissions, and that satisfies any hearsay. Ms. Ives' statements of the circumstances of her signing this order, the court will consider those. However, they go to the weight of the evidence and not the admissibility of the exhibit. So Exhibit 1 will be admitted. Let's look at Exhibit 2. Any objection to Exhibit 2?
I object to all of his exhibits. So you might as well just go ahead and just take that as the blanket right now. Just go ahead and ask me why each time. You don't have to ask if, I object. I do. Okay. I object to all of them.
All right. What is the basis for your objection to Exhibit 2?
I got to see what it is. I don't see it yet. I don't understand what the point of it is. No, but what's the point of it? What is it? What does it say that has to do with me getting my rights terminated? What does it say?
So Ms. Zayas has
Yes, thank you. A significant, well, really a pivotal issue in this case is going to be the mother's mental health and the mother's ability to work with DCFS and her lawyers and anyone in the system to remedy her parental deficiencies. And so both this exhibit and Exhibit 3, which are both declarations that she submitted during the course of the 2014 dependency cases, demonstrate a very drastic difference in her mental state and her ability to cooperate, her ability to engage in remedial services and to put the interests of the child and the safety and welfare of the child over her own emotional needs. So that is the purpose of Exhibits 2 and Exhibit 3.
Try to get me to try to force me to do services with Black people? Is that what it is?
The court will admit Exhibit 2. Relevance is simply evidence that makes a fact more likely to be true than not true, and minimal relevance is sufficient to admit Exhibit 2. Ms. Zayas, do you have the same objection to Exhibit 3, the same basis, relevance?
You've never done this to a Black person. I guarantee you haven't.
The court will admit Exhibit 3. It is also relevant, at least minimally relevant to the issues in this case. All right, Exhibit 4 is simply a motion to dismiss. It records an act of the court. I'm sorry, it's an order of dismissal. It records an act that the court took. And what is the basis for your objection to Exhibit 4, Ms. Zayas?
I've never seen any of these court documents, but she would just go to court and do it.
All right, thank you, Ms. Zayas. So the court will admit Exhibit 4. It is simply a public record recording an event. All right, next exhibit, Mr.
Thank you. And so now we turn to a number of exhibits that pertain to the current open dependency in case number 20666-0, Seattle. The first of these is the 72-hour shelter care hearing order, number 5.
Ms. Zayas, what's the basis for your objection to number 5?
Is that the shelter care order from this year or from 2000? Yeah, I never seen this or anything. I thought this was signed by my, this is the one, this is the forgery. Yeah, this is the forgery. And
the court will admit Exhibit 5.
I don't understand why, if I object to it, why do you admit it anyway?
Well, as I explained, Ms. Zayas, each party has the right to offer exhibits, and then the opposing party has the right to object, and then it's my job to rule on the admissibility.
So you're saying that it's okay to have, you're saying that this forgery is good. It's a good document. Is that what you're saying?
I'm in process of making my record, so let me finish explaining why I'm admitting it, and that might answer. So the court will admit Exhibit 5. It is a certified court document that records an event. Ms. Zayas's impeachment of this document as her allegation that it's a forgery, again, will go to the weight of the evidence, not its admissibility. And should such evidence come forth at trial, the court will consider it in its determinations. So Exhibit 5 is admitted. Go ahead, Mr. LaRosse.
You just committed forgery yourself, right? Right? So, you can't track that document, right? You just committed forgery, right? That's what I'm hearing. I just want to make sure I'm right.
The court has admitted Exhibit 5.
So you just committed forgery, right? When you approve it, when you approve a forged document, you just committed forgery. I just want to make sure I'm hearing it right.
The court hasn't approved a document. The court has admitted it into evidence as a piece of evidence that the court will consider. The court is bound to hear testimony about the document, including testimony from you, Ms. Zayas. So when we get to testimony, I will hear any testimony that you have about Exhibit 5 and the circumstances of it, and I will consider that in my decision.
Got knocked out last year. All my exhibits got taken out, and I didn't have no right to say anything about it, and they were not. She didn't approve any of my exhibits. Okay. Well, but the state gets all their exhibits approved, huh?
So, Ms. Zayas, you will have an opportunity to testify about this exhibit, but right now I'm just simply.
Next exhibit, Exhibit 6, is a copy of the clerk's minutes taken from ECR regarding the Regarding the shelter care hearing, that's the subject of the order, Exhibit 5, as the court can tell, there's going to be some discussion about whether that hearing occurred, whether there was a forgery. I'm not going to spend time in this hearing with the audio recordings, but I am asking to submit the court's minutes for the court to, in relation to the mother's claim that the hearing did not occur.
What's the hearsay exception, Mr. LaRosse?
Well, this would be a publicly recorded document, and pardon me, I have to look this up.
And I agree with you, it is a publicly recorded document, but it does contain statements that you're offering for their truth.
So I'm just looking to see if there's a substantive statement other than a ministerial recording of events. Pardon me one second. I believe that this would fall under RCW 544.010. However, this particular document is not an order and has not been notarized, so I'll have to get a notarized copy. I'll withdraw Exhibit 6.
All right, so the court is not admitting Exhibit 6. The state has withdrawn it, and I will not write refused because you're withdrawing it. What's the next exhibit, Mr.
The next exhibit is Exhibit 7. It is an order regarding the request to withdraw and setting a litigation GAL hearing.
And is this just offered for the purpose of recording the event, not the factual allegations therein or the factual findings therein, just the event of an attorney withdrawal?
It does specify certain facts that have occurred. It is a finding and order of the court, and as such would be admissible pursuant to statute, RCW 544.010, because it is a record of court proceeding. It's a court order, and it is per the prior order from the court entered March 25th of 2022, when we entered the pretrial conference order. It was stipulated and ordered by the court that electronic court records of copies of orders entered in dependency, termination, and parentage actions are deemed authenticated for purposes of admissibility. That covers the admissibility portion. And then the question of relevance is that these are records within the proceeding that underlies the current termination proceeding, and as a court order is not a statement of hearsay statement requiring the appearance of the judge to be cross-examined. It is a finding of the court.
I'm going to take a minute and look at it's time for our afternoon recess in any event. So let's take 15 minutes. We'll resume at 3 o'clock. And
Okay.
I'll be ready to roll then. Thank you. So, Ms. Zayas, were you able to email the information about your appointment on Wednesday?
I'm getting that right now.
Okay, thank you.
And Your Honor, while Ms. Zayas is working on that, I just wanted to interject that I had a little more to say on the question of admissibility of prior court orders.
Okay, we'll take that in just a minute. I don't want to do it while Ms. Zayas is preoccupied.
Okay.